Hey patent friends, welcome back to another video. So what is an obviousness rejection and where do obviousness rejections occur and how do you respond to obviousness rejections? So you may be thinking about filing a patent application and want to know about patentability and whether your invention may be rejected for being obvious, or maybe you're in the examination process right now and you've received an obviousness rejection. In this video, I'm going to lay out everything you need to know about what obviousness rejections are and how to respond, and to give you some insider tips on how to work with your patent attorney to effectively fight obviousness rejections. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney and author of the best-selling book, Patents Demystified, which is an insider guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel is all about giving you the insider tips and tricks about patents and the patent process, startups, entrepreneurship. So if you're looking for more content like that, be sure to hit the subscribe button and click that little bell icon so you don't miss any great new videos that come out. All right, let's go ahead and get right into it. All right, so obviousness rejections codified under 35 USC 103, which, sometimes you may hear them called 103 rejections as a result. So obviousness rejections, to understand them, we need to step back and sort of understand the patent process and where obviousness rejections are going to come up. Okay, so when you file a non-provisional patent application, it waits in line at the USPTO for 1 to 3 years before examination begins. So when examination begins, the examiner is going to do a prior art search and is going to determine a couple things. One is what you have, is it novel compared to the prior art? Now I have a video about novelty and I'll have that pop up here and have that in the link below. So novelty is there one single piece of prior art that has all of the elements of what you have claimed in your patent application? That sort of begs the question, what is prior art? So prior art can be really any sort of technology disclosure. A lot of times that could be the publication of an issued patent. It could be the publication of a pending application, whether or not that pending application ever issues or not, or it could be an old pending application that never issue. So it could be patent publications, but it could really be any sort of technology disclosure. It could be scientific papers, it could be blog posts, it could be actual products, say in a catalog, it could be YouTube videos like this one. So really any sort of technology disclosure could be used as prior art. Okay, so with novelty, it's just, does a single piece of prior art describe everything that you have in your claims of your patent application? So obviousness rejections are more tricky, and that's where the negotiation of examination is the most difficult. A lot of times getting over the novelty rejections, that's 35 USC 102, called 102 rejections typically as a result, those novelty rejections usually aren't that difficult. There's usually going to be something different between some piece of prior art and what the claimed invention is. And honestly, if we get novelty rejections, usually it's like, yeah, okay, we're going to be able to get over that. Usually that's pretty easy. Okay, so what are obviousness rejections? So with obviousness, the question is, would it be obvious to one of ordinary skill in the art, that being your average person who works in the field of the invention, to come to your claimed invention based on all prior art that is known? Okay, so examiners can combine many types of different prior art and come to your invention. So the way it works practically though is, let's say for instance that you have an invention that has elements A, B, C, and D. Okay, so the examiner would then do a prior art search and maybe would be able to only find a piece of prior art that only has elements A and B in this one piece of prior art, but then would keep on doing a prior art search and maybe would find another piece of prior art that has elements C and D. So what the examiner would do then is combine those references in an obviousness rejection and say, well, so if I were to combine these two references, A and B, C and D, then you have A, B, C, and D as in your invention. Okay, and then that's what the obviousness rejection would be, is the examiner say, well, it would be obvious to come to your invention because even though not a single piece of prior art has all the elements that you have claimed, these two pieces of prior art if you combine them, they would have all that. And sometimes the examiner can combine many pieces of prior art. I mean, it's not uncommon to have 3, 4, 5, maybe even 6 pieces of prior art that are combined to pull out all the elements to come to your invention. And that's why it can be really difficult to fight against in a lot of ways. So how do you respond to obviousness rejections? So you have a couple of options. So you can amend the claims of the patent application and or you can argue against the rejection. So let me kind of break those down as far as what the options are. So you have to understand that in a patent application, the metes and bounds of what is actually owned is defined by the claims. And so there's this claim section at the end. It's these individual single sentences that are awkwardly written. There's typically about 20 of them or so. That's what all the negotiation of examination is going to be. It's not about the description, or I'll call it the specification. It's not about the drawings. It's about this crazy claim section. That's where all the negotiation is. And it's important to understand that patents are not a binary thing. It's not just having a patent or it's not. You can have really broad patents that cover a lot of different variations of things, or you can have patents that are so narrow and so specific that they are effectively worthless because nobody would ever be able to infringe on them because they have so many elements and they're so specific. So that's something to keep in mind during examination. That's what this negotiation is with the examiner. So thinking about it like Pawn Stars or American Pickers, where you're haggling. What you're trying to do is you're trying to get the broadest claim scope possible. You're trying to get claims that cover the most variations as possible. Whereas the examiner has to make sure that what you have claimed is new and non-obvious. Okay, so you can amend the claims. You can add or change the language of these claims to try to differentiate over the prior art. But you can only do so within the scope of the original description and drawings as filed. That's sort of the big limitation when it comes to amending the claims. And that's really common, is doing claim amendments to differentiate over the prior art. And that's why it's really important to have a patent attorney do your non-provisional application, because you have to have a very detailed description. If you don't have all those details in there, you can't amend your claims to differentiate around the prior art. And that's what really patent attorneys bring to the table, is understanding, hey, what are the details that we need to have about the invention, which a lot of times is very counterintuitive, things that you would think was like, oh, well, this is obvious, this is really simple, but those end up being the elements that get you around prior art. So that's one option, is to amend the claims to differentiate over the prior art, or you can argue against the rejections. Maybe the examiner is misinterpreting your claims, of your application. The examiner is interpreting something incorrectly and is reading something on elements of the prior art incorrectly. These things are not analogous. Or the examiner is looking at pieces of the prior art, and the stuff that you have in your application, the prior art does not teach that. Absolutely not. The examiner is wrong. And sometimes examiners are just kind of lazy. They don't have a lot of time, and maybe they'll just kind of fudge some rejections, or just throw something out there and make you argue things. And sometimes that's necessary. The examiner is wrong, and you have to say, look, examiner, here are all the elements of our claims. The prior art does not teach these. In any of the prior art that you cited, even if you combine 2 or 3 prior art references, none of them teach these 2 elements in there. And so, you should withdraw those rejections, okay? So that's how you respond to obvious rejections. Now, how can you help your patent attorney do this, okay? So what I typically recommend is, break the claims down into their constituent elements and go through the prior art and say, hey, is this element present in any of the pieces of the prior art? And if there are things that the prior art doesn't teach, let your patent attorney know of things that are different, okay? That's one thing that you can do to sort of frame arguments as far as differentiating over the prior art. As far as like specific claim amendments, usually it's best to have the patent attorney frame those, because that's the whole negotiation. Sure, you could add a bunch of elements and you could, get cases allowed probably pretty quickly. But again, that may result in a patent being so narrow and so specific that it's effectively worthless. So it's important to negotiate and to make sure you're getting the broadest claim scope possible, because that's what results in a patent that is going to be really valuable. Okay, so you respond, you have really good arguments, or you're able to differentiate over the prior art with claim amendments. Then what happens? Okay, so then the examiner goes back and will do a new prior art search, and then may assert new prior art rejections. You may get over the original obvious rejection, but the examiner may form new prior art rejections. So for instance, if you say, hey, you didn't show that the prior art shows these 2 elements, or hey, we added these two elements and the prior art doesn't show that, the examiner could do a no prior art search and try to find those elements. So that's where this back and forth goes, is you amend the claims or you argue and the examiner tries to go and find prior art that has these elements, and if they can't find those things in there, the examiner will then allow the case, you pay an issue fee, and the application will be allowed. So that's kind of the negotiation and how obviousness fits into that. So if you got some value out of this video, give it a thumbs up. And if you're looking for more great content about patents, startups, and the patent process, be sure to subscribe, hit the little bell icon so you don't miss any videos, and check out these two videos as well. And thanks so much for watching, really appreciate it, and we will see you again in the next video. Thanks.